less serious crimes and concluded that no, it's just the opposite. In the less serious crimes, the tendency was to get it right. And what happens, again, as human beings is that there is this need for justice, this rush to judgment, the desire to nail the dude what did it, and to take that person in custody and make sure that he could never hurt anybody again. In minor cases, police take a look at the evidence and says, kind of convincing, but not really there. If they take it up to the prosecutor for authorization, the prosecutor will say, yeah, we really don't have enough. And so the bad cases are never authorized. If some questionable cases are authorized at the preliminary exam or at a pretrial, they wash out. But in the cases in which we have the most at stake, it turns out in the criminal justice system that the most mistakes are made. And that's something that I think that all of us as lawyers and judges and police investigators and defense attorneys and citizens have to be aware of. That the more serious the case, the more we have to check and balance ourselves, the more careful we have to be, because that is the place where more likely a mistake is going to be made. Well, getting back to this actual case. This case had a few problems at the preliminary exam. The victim, although a very sympathetic person because of her injuries, identified her attackers. Jeffrey Muldown was one of them. Some brothers by the name of Christini were others, and there was another person. And it turns out that one of the people that she identified was actually out of the state on that weekend. Another person clearly wasn't there as well. But then it turns out that two people were named, Michael Christini and Jeffrey Muldown. There was also another problem with the case, in that at the time of this attack, the victim was highly intoxicated. At the time that her almost lifeless body was discovered at about 5:30 in the morning, her blood alcohol level was at a 0.28, and she had reported not having anything to drink from the time that she left Clem's poorhouse in the city of Warren, terribly inebriated by her own admission, at slightly before sunset. And this is the summertime, and so we're talking somewhere in the 8:30 to 9 o'clock hour. Well, extrapolating backwards, if it were true that indeed she had nothing more to consume in terms of alcohol, her blood alcohol level at the time of her being abducted, somewhere between 9 and 11 o'clock, according to her belief, would have been at about a 0.42, which for those of you who have any familiarity with medical alcohol issues, is at a level that in some people can produce death. And a lot of times it would produce coma. But it would certainly leave you in a netherworld state where your ability to identify other people could certainly be questioned. And of course, if she had not been truthful, if she had indeed had other things to drink and didn't tell the police, that would have been another problem, because obviously if a person is telling you lies about something, it becomes impossible to know where the lies stop and the truth begins. However, these problems in her eyewitness identification were overcome by a couple of factors. The main one is that although she was kind of fuzzy about other attackers, it was pretty clear that as to this Jeffrey Muldown character, that even if she were highly intoxicated, she would probably have to get him right, because she had dated him on and off for some time. So this was a friend, this was a boyfriend, somebody that she had been voluntarily intimate with in the past. There is almost no ability to say that this was a misidentification unless she were possibly lying about something. And why would somebody who was so near death and had been so brutally beat up, why would she have any reason to lie? And so we decided to go forward with the case, but there was yet another factor, and that is that in those days, prosecutors' offices across the state, especially Wayne, Oakland, and Macomb, relied on a forensic odontologist by the name of Dr. Alan Warnick, who would give expert opinion on bite mark evidence. And Dr. Warnick had written and had talked about this and had testified in dozens of cases, and it was his belief and his teaching to us as law enforcement people that you could take bite marks and you could line up the ridges and the ups and downs and the peaks and the valleys on the teeth to get an identification that was darn near as good as fingerprints. Almost as good as DNA, that this was just really, really highly accurate. And Dr. Warnick had testified that some bite marks that were found on the victim, because this was part of, again, this extremely brutal assault, including biting, that the dentition of this Jeffrey Muldowan lined up with the bite marks on this victim. And so even though the victim was highly intoxicated and had misidentified other attackers, it seemed pretty safe to say that she was accurate in identifying her main attacker, Jeffrey, and we had scientific corroborating evidence to lock that away. The case was so tightly bound up, so well researched and ready to go, that at the time I vaguely remember that it was in the office, but being the prosecutor of a county of like 800,000 people with 60 assistant prosecutors and 10,000 cases going through the office, naturally I do not pay attention to every case. I would like to, but the ones that usually get brought to my attention are those that have some unique problem, some unique evidentiary problem, some particular high-profile reason to pay attention to them. And this one, in spite of that initial problem with the evidence, ultimately was judged by my chief trial attorney and others in the office as really not requiring Carl's attention, because after all, it was nearly a slam dunk with this Alan Warnick, and we're going to win this case anyway. There were no unusual evidentiary questions, and that was it. So the case went to trial, and the case was won. And then there's an automatic appeal that the defendants get to go up to the Court of Appeals, and that was taken. Again, all of this occurring in my office and on my watch, but nothing still to call it to my attention, except some vague memory. In fact, I still have today, because not the name Muldowan so much, but the Christini name, and I apologize to anybody who might be related to the co-defendant, but being a prosecutor, you hang out with cops, and you kind of get an idea of who are the bad actors in a town, and the cops were convinced that the Christini brothers were responsible for every bad thing that happened in South Warren. And so when this case went to trial, I wasn't saying, oh, this is the case against Muldowan. It was in my mind, oh, this is the case against one of the Christini clans. So it went to trial, won, went on appeal, and we in the prosecutor's office were successful on the appeal. Supreme Court, I think, turned down the application for leave because they don't have to take it. It was too simple, there was nothing at stake, and so by 1993 or so, the case, for all practical purposes, was over forever. This guy was going to be serving 40 to 60,
60 to 90.
60 to 90, big basketball scores. And again, that's kind of the lingo, the way that prosecutors and cops talk, basketball scores when we put somebody away for a long time, thinking that we've done a good job and patting ourselves on the back that we took this bad guy off the street. Now, it